First up this morning, the Don Blankenship jury is gone for the long holiday weekend. They'll be back Monday morning. Harvey Peyton, of course, has served as our legal consultant on this case. Harvey, good morning. Why do you think it's been more than 30 hours now of deliberations? Why do you think it's taking the jury so long, and why do you think they haven't reached a verdict yet, or verdicts yet?
Oh, I think it's a combination of a lot of things, Hoppy. I think first and foremost, the manner in which the jury was selected, although we weren't privy to that, because of the high visibility of the defendant and the case, many people would have been excluded who had a lot of knowledge. So that means a group of folks who read the papers and listen to the radio and are attuned to public events. And so that's not the group that's serving on this jury, and that's not a slam against the jurors who are serving. So you have folks who knew little or anything about the case. They have to be educated about the case. They're not professional problem solvers. And then they're confronted with just this mass of documentary evidence overlaying the testimony. And, initially they came out after just a day and a half of deliberations and said they, quote, could not agree. Then they were sent back by the judge without actually any sort of coercive instruction, and now have been out for another 4.5 days.
All right. Well, help me understand that, because it was pretty quickly they came back and said, well, we can't agree. And of course, that wasn't going to fly. But how do you go from, what does that tell you is that very quickly they want to say that they can't agree. Now that they go on for another 4 days and still can't agree, does that mean that they really can't agree? Is that what we gather from that?
Well, they haven't said that. I think initially it sounded as if there might have been strong recalcitrance on one side or the other. Maybe they took a vote or two and it came out disproportionate in one way or the other. And they're not professional jurors. Their question is, how long do we have to deliberate? We cannot agree. That was the question. How long do we deliberate? We cannot agree. Mm-hmm. So they failed on their first attempt. The judge said, you have to go back and deliberate further. It's not been that long. And now they've taken 4 days. They haven't sent any more notes to the court expressing a deadlock. Now, they did send a note asking to have some terms defined, and they sent one note because they felt that a reporter had improperly attempted to contact one or two of the jurors. That's it. They left yesterday without coming into the courtroom. And
did that surprise you that, and everybody makes kind of a sport out of when will the jury come back and what will it say, but you would think coming up against that holiday, human nature being what it is, I thought it would be last Friday that they would have, okay, let's get this wrapped up, but they didn't.
Well, that's a thought that runs through my mind as well, but that really shortchanges the integrity of the jury.
Fair enough.
These are 8 women and 4 men who appear to be honestly trying to do a good job. They're taking some time. If there were some shenanigans in the room or there were marked sharp disagreements, I think we would have heard some notes sent to the judge. They're 8 women and 4 men, just like the rest of us. They're selected from counties in central West Virginia, trying to do a good job. Mm-hmm. And trying to figure it out without leaving any part of the case unresolved.
Are you surprised it's gone this long?
Oh, yeah, I am. I'm not, honestly, have not been involved in a case where, I was involved in a large case here years ago. We had 3 days of deliberations. It was a civil case, not a criminal case. Been involved in a criminal murder case where the deliberations went on for 2 days. But this is, even given the volume of testimony, these folks come in at 9 o'clock. They get a break to smoke or to relax about 10:30. They go back to their room around 11 o'clock, work till noon, come back at 1:30 and don't leave until 5. So they're getting about 7 hours a day, 6.5, 7 hours a day of work. Of course, nobody works all the time. Some of that, I'm sure, is chit-chat or reacquainting after an evening off. But, let's say it's 6 hours. That's 30-plus hours of deliberations. That's a lot. That's a lot of time.
If obviously there is dispute among the jurors about conclusions on one, 2, or all 3 of the charges, was there anything in the instructions to the jury, and we know there would be if the judge gave them the Allen charge, which says, get back there and kind of reads them a little bit of the riot acts. Was there anything in the instructions that says you have an obligation to not only review the evidence, but to not be recalcitrant, that to listen to other sides and to reevaluate your position. If you think, is there any sort of charge like that to them?
Mildly so, yes. In the charge, there was included the general jury instructions, which you have a duty to deliberate. You have a duty to pay attention to your other jurors. You should not disregard because of pride or prejudice or obstinance anybody's position, and you should weigh those things and consider them. That's a part of the jury instructions in every case, and that was given to these folks. But again, they've never been jurors before, and they're confronted with, this is a close case. I mean, you had a segment on yesterday, late in your show, asking people, what should the verdict be, and when will we get one? And I listened to that. I was in the car, and the split is almost exclusively on the folks' outlook. When someone calls in who's had a prior relationship with the management side of coal, then, well, this should be a not guilty verdict. You can't go to the boardroom and on the other side, I mean, and I see it in the courtroom where the families are sitting. I hear their commentary that, we want justice. But will it be justice if the system runs its course and the man's acquitted?
Well, it will be justice if he's acquitted, for those family members, and this is hard to say, but for those family members who want justice, I'll use that with a small j, but with your observations of the trial, if they come back with acquittal, that's justice with a large J. I mean, that's how the system works, and it has not been a fix. That's what it is, whatever they do. I mean, I don't know what else to say about that.
Yeah, I mean, and in the courtroom, it was interesting one day about 2 weeks into the trial, in the afternoon, the family members who are always seated in the front, they came in after lunch, and they talk about justice. They talk about the 29 men who aren't here to testify.
Right.
Because to them, justice is a guilty verdict. Sure. Well, on that same day, Bill Maloney was in the courtroom. I just recognized him because he was a public figure. He's a businessman from Morgantown, and he was involved in the drilling, the 33 miners rescued. And when he left the courtroom, he spoke with a fellow who's a businessman that does some business with Massey, and it was obviously that those two men, looking at it from a business perspective, felt that the prosecution was that justice would be an acquittal, and a quick one. So it's how you look at it, and I suspect some of these jurors have a little bit of that. Nobody comes in as a blank slate.
Right.
It's just like judges. No judge looks at things completely in the abstract because they're human beings.
And it is, Harvey, we come back to this. It is, and you've been there every day. You're a lawyer. You're an unbiased observer. It is a close call, as we have said many times. If you're on the jury in a murder case, and that can also be a close call many times, but lots of times the evidence sort of piles up and it sort of tips one way many times, or in an armed robbery or whatever it is. But this is a much more, gosh, I mean, you're supposed to be objective, but still there's a level of subjectivity to it.
Well, there is a level of subjectivity, and it's interesting. There are a large number of members of the press, the local and the state and the national press, and I've never been a reporter. I'm not now. I'm just a legal observer, but you get to see people and speak with them in the hallway, and then invariably you'll say, well, what do you think? And I say, well, I'd really like to see him convicted, but, that's sort of an attitude that some have that, I'd like to see him convicted, but, is there enough here? That's a large but. It is indeed. And,
Now, Harvey Peyton's with us, who's been our legal analyst throughout this trial. How long will the judge let them deliberate before you get to hung jury status?
Until they say they can't agree. I mean, it's in the hands of the jury right now. I would assume there reaches some point, just the passage of time might imply a deadlock, and the judge might inquire of the jury. But, appellate courts are really hesitant to interfere with the judge's discretion in handling jury deliberations. If this thing goes another 5 days, if the jury doesn't come back and say we're deadlocked and can't agree, it really isn't the position of the court to interfere with that. they're entitled to take as much time within reason as they need to. Now, if it goes another 5 days, something's going to happen. She's going to intercede, and she's going to ask these folks or tell them, look, are you deadlocked?
She can't inquire. Can she inquire?
Well, she can, but she's not going to. I mean, that would be inappropriate.
Okay. Now, the defense, each time that there's a break, the defense, I think they've made 3 now motions for mistrial saying the jury can't reach a decision. Explain to me, Lee, that's a matter of course, isn't it? And the judge is not going to grant that, at least not at this stage, correct?
Not at this stage. And actually, they made more than that. Every time they reconvene, either Mr. Taylor or one of his other lawyers moves for a mistrial saying it's been too long, it's been too long. Because, obviously, at some point it denies the defendant of due process.
Right.
If it becomes coercive, if you keep people locked in a room against their will and tell them you have to decide this, then you're coercing them to make some decision to gain their freedom. We haven't reached that point because, as I say, after that Thursday, the jury...
Yeah, they've been deliberating.
They've been deliberating.
They haven't been sending back notes saying we can't get there, we can't get there. Right. And then you keep sending them back. Then there might be more support for that motion, but you would presume, you have to presume they are deliberating since they haven't sent any message back, right?
Right. And appellate courts really pay attention to jury deliberations and jury verdicts. I mean, that is the linchpin of the entire system. If this jury comes back, say, Monday or Tuesday of next week, and they have, say, a split verdict where they hang on one count, convict on one, acquit on the other, an appellate court, unless there's some underlying error in the way the trial was conducted, just those jury deliberations are not going to be sufficient.
I got it. Harvey Peyton, we got to leave it there. Appreciate it. Have a good holiday weekend. We'll resume with you next week, okay?
I'll be down in Vegas watching Hugs take on the opposition.
All right, very good. Thanks, Harvey. Enjoy your holiday.